Hi, as you will know, the SRA issued on the 13th of January 2025 their guidance on sham litigation. To me, this is an extension of their previous guidance on the Proceeds of Crime Act, which was last updated in September 2023. So what's in their sham litigation guidance? Well, you should always read the source material, so I will add a link. The sham litigation guidance is well presented into specific areas. In my recent newsletter, I highlighted some of the areas. Their guidance uses their terminology of must, should, and may. They state who the guidance is for. Note here, it is not just for firms in scope of the money laundering regulations. So please read their guidance carefully. The next section states the purpose of their sham litigation guidance, and thereafter follows an introduction to the three principal money laundering offences identified in the Proceeds of Crime Act, also known as POCA. The sections of POCA specified are Section 327, Section 328, and Section 329. They conclude the section by recommending that, I quote, that staff in all departments not subject to the MLRs have at least a basic knowledge of the risks of money laundering. I thought this an important point. The next section provides an explanation of how sham litigation works, and then the guidance states why criminals might find law firms an attractive arena for this type of sham. The guidance, I thought, helpfully provided what they term key indicators, others might term it red flags. So do have a look at that. The next section looks at how a law firm can protect themselves from the risks of sham litigation. You will note when you read the guidance that the guidance specifies what firms must do and what firms should do. They state, I quote, by implementing these strategies, you can significantly enhance your defense against sham litigation. I thought that the next paragraph in the guidance, interesting, they comment on the use of e-verification systems. They state, I quote, if you use an e-verification system, it is also important not to over-rely on it. E-verification will not tell you everything you need to know about a client or counterparty, but it can be helpful in highlighting inconsistencies in what you have been told. If you use one of these systems, it is also good practice to cross-reference the information available to you to enhance the accuracy and thoroughness of your assessment. The next section is a case study. You may have seen the individual in question reported on in the press, which makes an interesting and shocking read. But in the guidance, the focus is on one element of the fraudster's behaviour which applies to sham litigation to make their point. Definitely an interesting read. At the conclusion of the guidance, they refer to their previous guidance on POCA, which I mentioned at the beginning of this post. So read both guidances. Disclaimer: this post is not legal or regulatory advice, and you should make your own inquiries and make your own decisions.